Welcome to the United States Court of Appeals for the Fourth Circuit. We have three cases on for hearing this morning. First up, 23-2097 Williams versus Martorello. Mr. Gordon.
May it please the court, there are three reasons why the judgment in this case must be reversed. First, loans that are firmly rooted on an Indian reservation, that are made on the reservation by an arm of the tribe, cannot be outlawed by the state where the borrower resides. Second, the legality of the loans cannot be adjudicated in the absence of the tribal lender and the tribe itself, both of whom possess sovereign immunity. Third, RICO is not a strict liability offense, and Mr. Martorello cannot be found liable for violating RICO without proof that he knew that the loans were illegal and that the interest charged was at least twice the enforceable rate. I'll turn first to the issue of the governing law here. The court below ruled that, in essence, that all tribal lending conducted via the internet is off-reservation conduct that is subject to state regulation. And it relied on this court's decision in Hengel. But Hengel did not reach or decide that issue. The issue in Hengel was whether the court had jurisdiction over the parties in front of it who claimed immunity. And the court in Hengel said, based on the allegations in the complaint, that it had jurisdiction, the district court and this court, because A, those parties were tribal officials or members sued for prospective relief and therefore amenable to suit under an ex parte Young theory, and number two, because the complaint sufficiently alleged conduct that could be considered off-reservation conduct and therefore would give rise to jurisdiction. That was the only issue before the court in Hengel. That was the only issue it decided. It did not purport to decide that all tribal lending via the internet is off jurisdiction. And indeed, had it said that, it would have been announcing a rule that is contrary to the view that the Supreme Court has taken and other courts have taken for many years in loans that are across jurisdiction. The Supreme Court in the
in the Hengel decision where this court finds that the activities are directly analogous to the lending activity that other courts have found to clearly constitute off-reservation conduct subject to non-discriminatory state regulation.
Yes, Your Honor, that's what the court said in Hengel. And that was in the context of deciding whether the allegations in the complaint.
Right, but why wouldn't that principle also apply here?
Because, Your Honor, the Supreme Court in Marquette, for example, has said that a bank in Nebraska that provided high-interest credit cards to customers in Minnesota was extending credit in Nebraska, not in Minnesota. And therefore, that the Minnesota usury laws were inapplicable to it. The court said, the Supreme Court said 100 years ago in the Seaman case that a lender is free to extend loans that are legal in its jurisdiction to a borrower in another jurisdiction, and that is proper. The notion that in Hengel, in a case that was not, on an issue that was not directly before it, the court decided that all internet lending by a tribe is governed by the law of the state where the borrower resides, is directly contrary to those principles. It's contrary to the restatement of conflicts, which we have not suggested governs here because this is commerce with an Indian tribe, which is therefore subject to constitutional limitations. But just in a restatement situation, the governing principle under Section 195 is that the law of the jurisdiction where the loan is to be repaid is presumptively the governing law.
Can I follow up on that, Mr. Gordon? So is it your view that Hengel was incorrectly decided, or that
No.
that portion of the opinion that Judge Agee just described is dicta? I mean, what's your view about that, the import of the language?
We don't quarrel at all with the holding in Hengel. We think that the holding in Hengel is absolutely correct. But Hengel was not considering a choice of law issue. It was simply considering whether the allegations in the complaint were sufficient for the court to assert jurisdiction over the parties in front of it who claimed immunity. And those allegations were sufficient. But the choice of law issue is a fact-bound inquiry that's not made on a motion to dismiss, which is what was at stake in Hengel.
Well, I guess what I'm asking is the statement that the sentence or the phrase or that Judge Agee just quoted to you in Hengel, is it your view that that's just an incorrect statement of the law?
The cases that it cited, Your Honor, if you dig deep in, if you dig into them, really don't address the issue. They cite the Second Circuit decision, for example, in Gingras, which says broadly that a tribe engages in off-reservation conduct when it extends credit to a customer, a borrower in a state. But that's directly contrary. The Second Circuit, that's just a flat statement. The Second Circuit doesn't provide any rationale for it. That statement is at odds with Marquette, where, as I said, the Supreme Court said, no, the credit's being extended where the borrower, where the lender is located, not where the borrower resides. And also, that statement in Gingras takes no account of that court's own prior ruling in the Oto-Missouri case, which we cite. It doesn't, that panel, first of all, couldn't have overruled Oto-Missouri, and it didn't purport to. And Oto-Missouri, which we submit is the precedent that's on point here, directly considered the issue that is now before this court, which is a tribal lender making a loan to a customer, a borrower in a state, another jurisdiction, where the transaction's conducted via the internet. And the Second Circuit took that head on and said, under the Supreme Court's precedents, whether the state can regulate that has to be resolved through a Bracker analysis. And it said that on the facts before it, which were limited because it was an appeal from a preliminary injunction with a very limited record, it said that the evidence wasn't sufficient in that case to establish that the loans were sufficiently rooted on the reservation.
Does it matter that is it legally significant that the person being held to account here is not a tribal member?
No, Your Honor, because the issue here is the tribe's rights, not Mr. Martorello's rights. The issue here is whether the tribe can proceed with this conduct. These loans are being made not by Mr. Martorello, they're being made by an arm of the tribe on the reservation. As this court found in 2019, the lending business is very important to the tribe and to the reservation. And it was vital to its economic development. And the issue here is whether those loans can be outlawed by the states where the borrowers reside. And in order to...
Well, that may not apply to arguably to the tribes, but as Judge Diaz just indicated, Mr. Martorello is not a member of the tribe, and he's the one who's here.
That's correct, Your Honor, but the governing law would be the governing law. The law that governs those loans, which we submit as tribal law, is going to be the same regardless of who's raising the issue. Let me turn to the second argument. The legality of these loans cannot be adjudicated in the case against Mr. Martorello in the absence of the lender itself, big picture, and the tribe, and dissension, all of whom have sovereign immunity. The law is uniform, and the Supreme Court has held that when a required party is a sovereign that's not amenable to jurisdiction, the case must be dismissed. So once this court ruled in 2019 that Big Picture and Ascension have immunity, and the tribe clearly has immunity, indeed it was never sued, those three parties were absent from the case, and they cannot, the case cannot proceed in their absence. And the court below simply ignored the applicable law in ruling otherwise.
Why are they both necessary and indispensable?
They're necessary because it's the tribal lender, Your Honor. It's the legality of loans can't be adjudicated in the absence of the lender. Also, this court in Yashchenko has said that the tribe has interests that make it a required party in this sort of situation where a contract that is governed by its laws, or at least potentially governed by its laws, is at issue.
That's your argument for indispensable too?
I'm sorry, Your Honor?
That's your argument for being indispensable is?
Well, the Supreme Court in Pimentel has said flatly that when a required party has sovereign immunity, that the case cannot proceed. It must be dismissed.
So you think that's a per se? That's per se. Whenever
The
there's sovereign immunity,
cases
that anybody who joined with them in loan activity clearly, automatically, per se, is necessary, indispensable. Is that
Your
your
Honor,
argument?
The Ninth Circuit has said that, without calling it per se, has said that very little analysis is required when the required party has sovereign immunity, that in and of itself is sufficient.
So what effect does the prior settlement with these parties have on this particular issue?
The settlement, Your Honor, is inapplicable here. First of all, the tribe, which is one of the required parties, is not party to the settlement agreement. Second of all,
And the tribe has not sought leave to participate in this case.
nor is that required under Rule 19, Your
I
Honor.
understand that, but, I mean, if they had rights to defend, it would seem like that they would have taken some action.
Your Honor, their whole point is that they're immune and that they shouldn't have to be bothered with this. The First Circuit has clearly explained, and we've cited it in our brief, that no action is required by the absent party. Beyond that, to continue with the answer, the Ascension and Big Picture did not settle out of this case. They were dismissed from this case pursuant to this court's mandate in 2019, although the district court waited 6 months to do it until after the settlement agreement was entered into. Third, turning to the third argument, the court has imposed a $44 million judgment on Mr. Martorello for violating RICO for engaging in unlawful debt without any proof that Mr. Martorello knew that the loans were illegal and were twice the applicable interest rate. And in the face of uncontested evidence that Mr. Martorello had advice of counsel that the loans were legal. The court simply said that Mr. Martorello's knowledge and good faith and reliance on the advice of counsel were irrelevant because the RICO unlawful debt offense is essentially strict liability. And that, again, is not the law. There is no case, none, that has ever held that. And indeed—
Do you have a civil RICO case that adopts your position?
I have Supreme Court law that says that a case, that when you're talking about a statute, Your Honor, that is both civil and criminal, as RICO is, that it must be interpreted uniformly in both contexts. And that is what we rely on here. this is indeed a civil case, but the construction of what the RICO offense is defined in exactly the same way, regardless of whether it's a civil or a criminal penalty. And the court below held that when you're talking about the unlawful debt offense, that you don't need any knowledge or intent. If the debt turns out to be illegal and at twice the enforceable rate, even if you didn't know it, you are liable. And in the criminal context, that would mean you're guilty and could go to jail for up to 20 years. And that is not the law. The Supreme Court has made very clear that knowledge is required, scienter is required to, so that people aren't subject to criminal sanctions for otherwise innocent conduct, unless they knew that the conduct was illegal.
Isn't the default rule, though, generally that ignorance of the law is not a defense?
But we've cited the case law here, including the Supreme Court law, saying that mistake of law is indeed a defense in this context, Your Honor.
In the criminal context?
Yes, Your Honor. The Rehave case, Supreme Court decision within the last 6 years.
All right. Thank you very much, Mr. Gordon.
Thank you, Your Honor.
Mr. Wessler.
Thank you. May it please the court, Matthew Wessler for the plaintiff's appellees. 2 years ago, in the course of rejecting his last appeal, this court held that Mr. Martorello had lied about his ongoing role in the illegal lending enterprise that he created to sell predatory loans to Virginia consumers. These loans carried upwards of 1,300% interest rates, even though Virginia caps those rates at 12%. And Mr. Martorello himself profited off the scheme to the tune of nearly $100 million. In rejecting his appeal, this court also cleared the way for the Virginia consumers in this case to prove that because Mr. Martorello participated in and controlled the direction of the lending operation, he was liable under RICO. On remand, the plaintiffs did just that, and Mr. Martorello concedes that the record evidence in this case establishes virtually every element for both causation and damages. Instead of contesting any of the facts regarding his role, he now makes 3 legal arguments in a final attempt to escape liability. But as the discussion today points up, his first argument is foreclosed by this court's decision in Hengel. And just to be specific about Hengel, this court rejected an identical argument. The lenders in that case had argued that because the loan was, quote, allegedly made and accepted on tribal land, it was governed by tribal, not state law. And this court said that's wrong, and it held instead, consistent with every other circuit to have considered the issue, that online lending is, quote, clearly constitutes off-reservation conduct and is therefore subject to state, not tribal law.
Now, your colleague on the other side mentioned or referenced some Supreme Court cases in the context of non-tribal lending activity, commercial banks that are incorporated in one state and lend in another, and that the Supreme Court has held or suggested that those loans would be governed by the state in which the bank had been incorporated or was doing business. How do those cases, if at all, apply in this context?
I don't think they do apply in this context because the question of tribal law versus state law is different. Even my friend on the other side acknowledges that the inquiry, even assuming that you would consider the activity to take place on the reservation, the inquiry follows the Bracker test, which is a distinct test developed in this space that is outside the scope of the way that it works when you're talking about one state versus another state. But I think really the signpost for this court is Hengel, which went through in detail the inquiry that is required when a party is making an argument that the activity ought to be considered on tribal land. And what it held, and I'll just to be really specific, this is at pages 348 and 349 of the decision, is that the inquiry does not turn on where the loans were allegedly made or accepted. In Hengel, this court identified 5 factors that it said are...
Before you get to Hengel, so are you saying that because we're dealing with tribal lending, those cases that Mr. Gordon referred to with respect to non-tribal lenders just doesn't apply?
I think that's correct.
Why would that be?
Well, because the inquiry, it's a separate inquiry. Tribal law is treated differently from state law. The reason is because of the sovereign interest concerns that attach to the tribe when it is attempting to create economic activity on its tribal land. And so in those situations, neither federal nor state law would apply to its on-tribal activity. But what the Supreme Court has said in the context of tribal activity is when the tribe or tribal members go outside the reservation and pursue their conduct in states, they are subject to non-discriminatory state law. And that's the approach that this court.
Does it make a difference in that analysis that Mr. Martorello is not a member of the tribe?
We think it heightens the conclusion that in this case, the activity can't be considered on reservation conduct. It would be, I think, quite odd to be in a position where as this court said in Hengel, the activity is considered off-reservation for tribal officials, but it is somehow not considered off-reservation activity for a non-tribal individual. The key inquiry in this context is a series of 5 elements that this court identified in Hengel. It asked, first, does the defendant market the loans throughout the country, including Virginia? That was in Hengel, the first one. The second one is whether the plaintiffs reside on non-Indian land when they applied for the loans online. The third is whether defendants collect payments from the plaintiffs while they reside in Virginia, whether the plaintiffs' bank accounts are located in Virginia, and whether the effects of the illegal lending are felt by the plaintiffs in Virginia. All of those factors, there isn't any dispute here that all of those factors are satisfied. And so there's I think a pretty straightforward application of this court's decision in Hengel to this question here.
Yeah, but those factors would be satisfied. Following upon the Chief's question, interesting that categorically, just because it's a tribal nation involved, it should be treated differently in terms of a state. You seem comfortable with the fact that you don't take issue with your learned colleague says that when states, one state, we're going to keep it, the law applies there, no matter the fact that it's another state where the loan is. Why should it be treated different because it's tribal? Seems to me the tribal would have more autonomy than states would in that sense. Is that some kind of discrimination here?
No, I don't think so. I think
What is that?
if you had a situation where you had a lender who had erected this kind of lending scheme in one state and then directed their lending activities into another state, that second state, in the same way that it would happen here, would apply its non-discriminatory state law to that lender. So a lender cannot escape, for instance, a Virginia interest rate cap, which is 12%, by incorporating its lending in Minnesota, but nevertheless directing its lending activities in Virginia. So there's the same rule that is going to apply in this context.
And what case is that you're citing?
Well, I don't think that's, I
I didn't think so. I didn't think so.
Yeah, I don't have a case for that.
You're citing yourself.
Well, I think that's the application of non-discriminatory state law applies. The whole idea is that it's non-discriminatory. It applies regardless of who the party is that's violating that law, whether it's a tribal official, whether it's someone like Mr. Martorello, who is who's responsible for originating and collecting these loans, or whether it's someone from a different state. Either way, that non-discriminatory state law will apply if the activities are directed into that state. And there is, again, no dispute here that all of the activities, the collection of the loan, the origination of the loan, the attachment of the plaintiff's bank accounts, that all took place in Virginia. And so we really are foursquare with what this court said the controlling law is in Hengel, which is that, just a quote from Hengel, substantive state law applies, and lending activities like this are considered off-reservation conduct. And it drew no distinction in that case between the identity of the parties, whether it was a tribal official or anybody else. And the court also drew no distinction between the nature of the claims. In that case, the claims at issue were injunctive-focused claims, but it doesn't matter here, the claims are damages. Either way, when you direct your activity into a state under this court's case law and also under controlling Supreme Court precedent, Bay, Mills, and Wagnon, if you direct your activity into the state, you are subject to the non-discriminatory state law just like anybody else.
I'm sorry to beat this horse, but I have a recollection that many lenders incorporate or base their operations in one of the two Dakotas, I forget which one, because of the fact that those interest rates in the Dakotas are much higher and allowed to be much higher in that state, and then project their business into other jurisdictions. Is it your view that they are that they would be subject to the lower usury rates in those states, and there'd be an anti-discrimination complaint against those lenders?
Well, I think it depends on the facts of those cases. So for instance, if those lenders had a choice of law clause that specified North or South Dakota law, you might be in a different situation. But I think if you are, outside of a world in which the contract specifies which law governs, I don't think you could escape the application of Virginia law by directing your activities into the state. I mean, I'll also say here that what we're talking about is a federal RICO claim. And one distinction that exists between, Judge Diaz, your hypothetical example of a North Dakota or South Dakota lender and a tribal lender is that the tribe takes the position that, it is immune from federal law. A North Dakota lender who is violating RICO could not escape accountability or liability under RICO simply by incorporating in that state. And so I think there is this distinction that I think Hengel recognizes, which is that tribes are in a different position, in some respects at least, to lenders who are operating their enterprise in a state. If I could turn.
Well, then that makes it more important in terms of the case of indispensable. You're talking about whether or not it was on reservation activity or not, that they need to be here to determine what in fact they do, isn't it? Then that dovetails back to
Sure.
counsel's
So
argument.
if I could respond to this question about Rule 19.
Is that my question I just asked you? You can.
Thank you. So, I mean, there are two
My
elements.
question, yeah, my question.
Yes, which is
No,
indispensable parties.
No, yeah, what I just asked you, that you're here now, this question. Answer
I'm
my
sorry,
question.
could you-
Answer my question first.
I'm sorry, could you repeat the question?
You didn't hear it, or you didn't hear the question?
I thought it was focused on indispensable parties.
Well, go ahead, since you didn't hear it.
Okay, I mean,
You argue the case the way you want, since you didn't hear my question.
if I understood your question, it was focused on indispensable parties under Rule 19. And I think, what I heard you ask was, doesn't the tribe need to be here? And in this case, I think the answer to that is no, because the tribe voluntarily settled its claims out of the case. And so it's not like a situation where you've got, an absent party who, may have some interest, and there's a concern that those interests might be prejudiced in some way. Here, you have a situation where the tribe, the tribal officials, the tribal entities, Ascension and Big Picture, all voluntarily settled their claims. And in a situation like that, courts have uniformly recognized that when a party voluntarily takes themselves out of a case, there isn't a concern that their interests are going to be prejudiced because they're capable of deciding whether to remain in the case or not. And so I guess I don't think that that in the abstract there might be a concern about prejudicing interests, but here you have a case and specific facts where all of the absent parties have taken themselves voluntarily out of the case. And I think that addresses both the necessary party element of Rule 19A, which asks basically two questions. The first is, can the court award relief, complete relief to the parties who are in the case? Here we have a situation where there are no injunctive or declaratory relief requests in the case. This is only a case involving money damages against Mr. Martorello. So the tribe's interests there are not prejudiced, and there can be an award of complete relief against the defendant. And you don't have a situation where the tribe's interest can't be protected because they settled out of the case voluntarily. And that demonstrates that they didn't feel like it was necessary to remain in the case. And I think on this point, it's just worth noting that they were fully aware that the case would proceed independently against Mr. Martorello. In the settlement agreement itself, that was a part of the agreement. And not only were they aware that this case would continue on against Mr. Martorello, but in the settlement agreement, they agreed to assist the plaintiffs in their prosecution of their claims against the remaining defendant. And so I think as courts have said, it would be inappropriate to allow a party who remains in the case to champion the interests of an absent party when that absent party has voluntarily chosen to take themselves out of the case.
Does Mr. Martorello have any remedy against the settling parties?
Against the tribe, no, Your Honor. There isn't. There is nothing in the settlement agreement or anything that certainly is in the record in this case that suggests any kind of remedy against the tribes. And I think, if I'm understanding Your Honor's question, I mean,
Well, was Mr. Martorello a party to the settlement agreement?
no, he was not a party to the settlement agreement. The settlement agreement only.
So he could not have waived any rights he may have.
That's correct, Your Honor. This is the kind of situation that comes up actually with some regularity, and it's the joint tortfeasor problem. And what courts have said in the context of a joint tortfeasor case is that Rule 19 isn't implicated when there might be one of several joint tortfeasors who is not in the case. And so I think any potential downstream consequences of a judgment here isn't implicated when you're asking a question about either necessary parties under Rule 19A or indispensable parties under Rule 19B. And there just isn't anything in the record in this case that suggests that should matter. Now, the one thing that, and I haven't heard, I don't think in the briefing Mr. Martorello didn't make any argument about that possibility. The only argument he made in support of his Rule 19B indispensable party claim was that there might be economic interests of the tribe that would be affected. But that isn't actually, there isn't anything in 19B that suggests that economic interests of the absent party are sufficient to justify what he's asking for here, which is complete dismissal of the case at all. And the tribe is free to continue lending in whatever way it sees fit. This case and the claims against Mr. Martorello don't run at all to the tribe or to the tribal officials or to the tribal entities. And so it really is independent of anything that the tribe might want to do in the future. If I could turn briefly to Mr. Martorello's third argument, which is an invitation to the court to impose a mistake of law defense in a civil RICO claim, there is no case that has ever adopted that requirement. And I think there's a good reason for that. It's because the plain language of RICO does not permit a court to engraft onto either 1962 or 1964 a requirement that in a civil context, a defendant has to be shown to know that his conduct was unlawful. The keystone case, I think, that sets the framework for this, there's actually two. One from the Supreme Court is a case called German, where the court said when Congress intends to provide for a mistake of law defense to civil liability, it does that explicitly. And it said in that case, it must employ language like actual knowledge or knowledge fairly implied. And there are examples of this in the US Code where there's a civil statute that imposes liability for civil penalties where Congress has expressly required a heightened knowledge requirement. But RICO doesn't have anything in the statute that comes even remotely close to that. It's much more similar to another racketeering provision, Section 1955, which this court addressed in US versus Lawson. And in that case, the defendant that's a criminal case, so it's even a different context than what we're talking about here. But in that case, this court addressed a defendant's argument that under Section 1955, the government was required to prove knowledge that the underlying conduct in a predicate state law offense was unlawful. And this court rejected that argument, and it said we begin and we end really with the plain text of the statute. And if the statute doesn't impose such a requirement, we're not free to introduce it into the statute without Congress
So
actually doing it
hypothetically, if the state required you to be 18 years old to enter a contract for debt, in fact, the person lied about it and they really were 16, but they signed it and you loaned them money, then you could be subject to RICO, right, solely, and you not know anything about the person's age, simply just because the loan was unlawful? Is that your position?
Well, no, I think the facts matter here too, and I guess I have a question about that hypothetical. What's the nature of the underlying state law violation?
I just told you that hypothetically, you cannot enter into the contract to assume debt or credit unless you're 18 years old. The person, in fact, lied, and they're 16. So that makes it unlawful. So if you're reading RICO, it means all it requires it for it to be an unlawful debt. Whether you knew it or not, you're saying that you'd be liable,
Well,
right? I'm just gonna make sure, let's get that structure of my question first. Are you saying that that's right, based on the way you read RICO, under my hypothetical, you could be guilty of RICO, even you say, I had no idea the person was 16 years old, and you say, oh, it doesn't matter, so.
No,
So enter, it doesn't matter.
No, I don't think
What is it then?
that's correct. RICO is a general intent statute. So-
General?
General intent, yes. And so we are not in a world where what we're talking about is strict liability. What's required is that you have to be able to prove knowledge of the basic facts of the enterprise or of the conspiracy to trigger liability under RICO.
There's
And
no
so-
conspiracy here, other than the fact that that the loans you said were too high, the interest, right? And if you believe that you weren't required to follow that, instead you could use a different law, what's the difference? There's no different real scenario other than that, isn't it?
No,
First of all, RICO is overused anyway. It really was for people involved in organized crime, and then it morphed into now whenever you want to be more punitive to people, you charge RICO sometimes. But anyway, tell me why then all you have to show is what? What do you have to show for RICO? For knowledge?
Judge Diaz, may I answer the question?
Absolutely.
Yeah, so, I mean, you have to show that the individual had knowledge of the basic facts surrounding the offense. So that they knew that what they were doing, at some level, they have to actually know the predicate facts.
They
Now,
knew what was legal, they knew they were charging too much interest?
yes.
But suppose they thought in fact, legally, they could do that.
Well, I don't think that's a defense to a civil RICO claim, and there isn't anything in the statute that suggests it is.
But then
There is
it's a tautology. You say, well, there is a scienter, it's not strict liability, and then when I say that, then you say, oh, but they have to know. They have to know something, don't they?
yes, they do have to know, yes, they absolutely have to know something, but the something here is that their loans,
Or unlawful.
no, that their loans are over double the legal limit. So RICO it defines unlawful debt in the statute in 1961. And it doesn't turn on just the violation of the underlying state predicate law. So for instance, Virginia's state usury law is 12%, okay? Let's say someone was lending at 13%, okay? That would not trigger a RICO violation. RICO has built in a safeguard for the kind of innocent mistake, concern.
Or it has, what's the margin of error then? Plus or minus what?
No, so what the definition in RICO is double the legal limit.
Uh-huh.
So it does not do what I think Mr. Martorello is attempting to say it does, which is trigger liability for innocent mistakes or, any other kind of conduct where you don't know. You have to be lending at double the legal limit of the state law to trigger liability under RICO, and I think that takes care of the kind of innocent mistake concern that might be at play in some context. But if I could just spend 10 seconds summing up here, I think the key takeaway that I would urge this court to have here is that there isn't a single court anywhere in the country that has suggested that civil RICO requires proof that a defendant has knowledge that their conduct is unlawful. And so this court, what Mr. Martorello is asking this court to do is to adopt that for the first time, and not even in the criminal context, but in a case that only raises civil claims.
Mr. Wessler, just want to understand your position with respect to knowledge. I thought I heard you say that the defendant needs to know that, in this case, that charging interest at double the rate of the, whatever the interest rate is by statute, has to know that that's unlawful. But doesn't that require some knowledge of what the legal rate is?
Sorry, I did not mean to suggest that the defendant needs to know that the lending is unlawful under state law. That isn't a requirement under RICO. It would be a requirement if the statute included specific knowledge requirements. What the defendant needs to know is the facts of their lending. They need to know the interest rates of their lending, and they need to know that they are offering these loans at a specific percentage, and if that percentage is in fact over the double, is more than double the legal limit of the state, they can, if the other predicate elements are met, be held accountable under RICO.
All right.
Unless the court has any further questions.
Thank you. Mr. Gordon.
Chief Judge Diaz, I want to pick up on your recollection, which is correct, that in the credit card context, all of the banks incorporated in South Dakota because South Dakota allowed high interest rates. And those interest rates have been upheld because they were legal in South Dakota. And that's what Marquette said. So the court is exactly right. And Hengel, it does not establish a contrary rule that says, oh, when it's an Indian lender, it's always the law of the state where the borrower resides. That would stand established law on its head and would put Indians, lenders, Indian tribes in a worse position. And moreover, it would allow states to control commerce with Indian tribes, which the Constitution says they can't do. The Constitution says only the federal government can do that, and the federal government has not chosen to regulate internet lending. Further, to tie that in to RICO, according to other counsel, if the lender in South Dakota makes a loan, if it's a non-Indian lender, thinking that South Dakota law applies, and it's perfectly legal under South Dakota law, but it turns out to be illegal under Virginia law and more than twice the rate, ipso facto, that lender is guilty of violating RICO and can get the punitive sanctions of RICO. In other words, according to counsel, it is a strict liability offense. That is not the case. RICO is not strict liability, and it requires, under the Supreme Court's precedents, and the Supreme Court's precedents here, the counsel cites German, but that's a purely civil case. We have here a statute that has civil and criminal aspects to it. The offense is defined uniformly. Therefore, it's the same definition as 1962 applies both to civil and to criminal. And the issue here is what intent do you need under 1962? So whatever rule applies will apply in both the criminal and the civil context. And the Supreme Court has clearly said that in that context, you must know that what you're doing is unlawful. And in order to be unlawful, under RICO, there are two elements. One, that the loan, in fact, is unlawful, and number two, that the rate being charged is at least twice the enforceable rate. Here, there's no proof, because the court below said it wasn't necessary, that Mr. Margarello satisfied either of those. Now, turning, if I can, to Rule 19, counsel repeatedly said that the tribe voluntarily settled its claims. Not true. The tribe was not a party to the settlement agreement. And the settlement agreement, insofar as it covered big picture and ascension, didn't involve this case because they had already been ordered to be dismissed from this case pursuant to this court's 2019 decision. The counsel says all of these parties voluntarily took themselves out of the case. Not true. The tribe has never been a party to the case. The tribe has never consented to anything. The counsel says that under the settlement agreement, Ascension and Big Picture said, oh, it's fine if the case goes forward. Again, that overstates what the settlement agreement said. The settlement agreement simply says, because the Ascension and Big Picture, there's no waiver of immunity other than that necessary to enforce the agreement. What they said was that if the case went forward and if there was a need for documents they had, then they would provide documents. And the reason that provision is there is that because of their tribal immunity, absent that sort of provision, they might have been able to stonewall under cases that we've cited, providing those documents. So there's been no consent by the tribal parties to this case proceeding in the sense of, oh, we think it's fine.
Well, I understood Mr. Wessler's argument to be that the tribe could have remained a party or to this litigation or voluntarily injected itself into the litigation, but it chose to seek dismissal because of sovereign immunity. And then it seems odd then to say that having opted not to participate, they are now necessary parties.
Your Honor, the tribe was never a party.
Okay, but I suppose they could have sought to intervene, right, if they thought that their rights were being impacted?
But Rule 19 doesn't require that, Your Honor. In fact, Rule 19 sets up precisely the opposite, saying that you need not intervene and that the court must consider the interests of absent parties. Moreover, Big Picture and Ascension were dismissed by pursuant to this court's ruling that they had immunity. In Pimentel, the Supreme Court case that we cite, the sovereign was the Republic of the Philippines. And procedurally, it had been included and then it was dismissed because it had immunity. And then there was the Rule 19 motion, and the Supreme Court in that posture said the Rule 19 motion had to be granted. That is the procedurally what happened in Pimentel, and we suggest that that is exactly the same situation that is now in front of the court here.
All right, thank you, Mr. Gordon.
Thank you, Your Honor.
I want to thank both counsel for their arguments this morning. We'll come down and greet you and move on to our next case. Please be seated. Our second case is 24-1799, and there are a number of other related cases. Kipke versus Moore. Mr. Patterson.
Morning, Your Honors. May it please the Court, Pete Patterson for the Novotny plaintiffs. Before Bruin, Maryland limited the public carry of firearms to exceptional people. After Bruin, Maryland is now attempting to limit the public carry of firearms to exceptional places. But this is no more constitutional than the pre-Bruin regime, and in fact turns the Second Amendment on its head, as Bruin said that individuals have a general right to carry firearms in public locations, places frequented by the general public, subject to limitations in exceptional circumstances. Maryland's law is directly contrary to the principles that underlie the Second Amendment. As this court sitting en banc in Bianchi stated, the Second Amendment principally is about the right of people to protect themselves when the government cannot. And that is consistent with the principles that we are offering this court, but it is diametrically opposed to the principles that Maryland is offering this court. Maryland says that it can ban firearms in places of public congregation and places where vulnerable people are present. But if the government is not protecting those locations, those are locations where the need for protection is enhanced, not diminished. And the founders knew this. Leading up to the founding of this nation, a majority of the original 13 colonies required people to take firearms to places where people were vulnerable and places of public congregation, such as churches and other public assemblies.
And you're going to get to the specific locations.
Yes, I'm
As you
starting
go
off
through.
on the degree
Okay.
of principles. There are so many specific locations, I'm happy to discuss any particular ones that the court has an interest in. But Maryland's arguments, primarily for most of the locations, they rely overwhelmingly on 4 post-1868 state laws that were enacted between 1869 and the end of the century.
Let me ask you
Yes.
a threshold question
Yes.
then. One of the grounds that's challenged, I believe, is the school grounds, the areas adjacent to a school, like the sidewalk leading up to the school or a playground or something like that. And the Supreme Court has said in all of the cases from Heller on that a sensitive place is a school or a government building, and they've never carved anything out of that. And you have made a facial challenge, not an as-applied challenge. So why would the playground not be considered a school under those pronouncements from the Supreme Court?
Yes, and the positions we are arguing are consistent with every word in Heller and Bruin, and I will explain why. What the Supreme Court said is that laws restricting firearms in schools and government buildings are not being called into question by what we're saying were presumptively constitutional. All laws are presumptively constitutional until they're challenged. Those laws weren't at issue. And they said, we'll save the historical justifications for another day. And then in Bruin, some more meat was put on that, where the court rejected some justifications for sensitive places. They said it's not places of public congregation. It can't be any principle that eviscerates the right to self-defense. But they, again, did not define the principles that underlie those restrictions. And what we have...
Why wouldn't the playground be part of the school?
Well, okay, Your Honor, so now I'm getting to the history with respect to schools, which the Supreme Court has not explored. And what that history shows is that the government has the authority to restrict...
Well, my point here with schools and government buildings is that's what they said. And they've said it several times, and they've never said, okay, here's how you're going to do a carve-out, saying an as-applied challenge. So what authority do we as a lower court have to carve out in a facial challenge some part of a school?
Well, my understanding of a facial challenge is what you do is you look at the face of the law, you apply the constitutional test, and you see if it satisfies the constitutional test. And here it does not, because the Supreme Court did not bless any restriction on any part of schools. And what the history shows is that the government could ban students over whom it has in loco parentis authority from possessing firearms at schools. And similarly, with respect to government buildings, the court provided further refinement in Bruin and looked at founding area polling places, legislative assemblies, and courthouses. And the principle that unites those, as we've shown, is government-provided security. And again, that is consistent with the principles that underline the Second Amendment, which state that people have a right to protect themselves when the government cannot. And the other side's attempt to...
Why wouldn't the Supreme Court have embraced that principle if that's the foundation in one of these, Heller, McDonald, Bruin, Rahimi, and that doesn't appear anywhere in there as far as I know.
It doesn't, because it was not necessary to decide those cases. Those were not sensitive place cases. The only holding with respect to sensitive places that the Supreme Court made was in Bruin, where it rejected the notion that any place of public congregation is a sensitive place. And it also rejected the notion that any principle that would eviscerate the general right of public carry is a sensitive place. And so that actually undermines the other side's principles that they offer here, because Maryland is very clear. What Maryland says is that people only have a right to carry firearms on streets and sidewalks. They say that all other government-owned property, firearms can be banned, and they make the astounding claim that in public and private property that's open to the public, that the text of the Second Amendment does not even reach those locations. So again, this flips Bruin on its head, which said that people have a general right to carry in places frequented by the general public, subject to limitation only in exceptional circumstances. And the Supreme Court did not define, explicitly said in Bruin that we're not defining the scope of sensitive places. We're not saying what the principles are. We're saying here are some that it is not, and what it is the other side's burden to come up with valid principles to justify their restrictions. And we have offered a principle that we think is both consistent with the history and it's consistent with the principles underlying the Second Amendment. But the court does not need to adopt our principles to rule for us because it's plain that Maryland's principles are invalid. And again, that's what the Supreme Court did in Bruin, is it said that New York's principles are invalid. That's enough to invalidate New York's law. We, therefore, don't need to go any further. And with respect to the facial as applied point, I'll note that at JA 70 in the Kipke plaintiff's complaint, and the Kipke plaintiffs are the ones that are challenging the school grounds and the government buildings, they explicitly say we're bringing this both facially and as applied. So it's both a facial and as applied challenge in that circumstance.
Can I ask you about a different category?
Yes.
I mean, there's a virtual potpourri of places
Yes.
that we're trying to sort
Yes.
through. So government buildings is the one that I want to focus my
Yes.
attention on. And so before we even get to the merits of whether or not the tests that are being considered or being suggested by the parties is correct, you have to show that there's standing to raise the challenge. And so my question is, with respect to government buildings, what is it in the declarations or elsewhere that suggests that any of the plaintiffs in this case intend to visit any one or more of the government buildings that are issued in the statute?
Yes, again, that's the Kipke plaintiff, so Mr. Sweeney can correct me if I'm
Oh.
incorrect, but my understanding
Okay.
is that Ms. Kipke says she wants to go to a demonstration on the Lawyers Mall on the Capitol grounds. And so the government buildings includes the grounds of the government buildings, and so that is in the declarations. I believe they started around JA 80 and then go on for the next 40 pages or so of the
Well,
JA.
maybe I'll ask your colleague that question, but since he probably is better versed, so go ahead.
No,
The
okay,
rest of your
Your Honor.
argument.
Yes, and so I also do want to get to the no carry default, which is a very extensive part of Maryland's ban. Is explicitly the academics, Ayers, and his co-author who promoted this said that this will drastically expand the places where people can't carry. And this is diametrically, again, opposed to Bruin, which said that people have a general right to carry in places frequented
Well,
by
let me
the
ask you
general
about that,
public.
because the language in Bruin was not intended to be exclusive, right? They had a number of descriptors, schools, government buildings, and the like, but it wasn't intended to be limiting, was it?
Well, they had a concluding part of Bruin where it said that people have a right to carry except in exceptional circumstances under which one could not carry arms, such as before justices of the peace and other government officials. This is
Well,
at
but,
JA 70.
Just to be clear, is it your view that the places that were described as sensitive spaces or places in Bruin is it? That's the sole places that we look at?
No,
Okay.
not at all. And I'll give this court, again, our principle, we say that unites these is government-provided security, where then the need for self-defense is not present. And I'll give an example. There is a McDonald's in Pennsylvania that was a sensitive place for one day in its history, when then candidate Trump appeared to work at that location. And that the Secret Service secured that location. No one could bring firearms into or out of that location. That was a legitimate sensitive place for that one day. So our test is actually very flexible and adapts to whatever the needs are of the moment. And it just makes common sense, and again, is consistent with the principles underlying the Second Amendment. What this court said in Bianchi is that there are some places that are so sensitive that we don't allow people to engage in armed self-defense because there's a risk that somebody with those arms would unlawfully use force against another person or a government official.
So what about the New York City subway system where police patrol? Is that a sensitive space?
No, that's not a sensitive space because they're not screening people. If a person can walk into a location unimpeded by a government official with a firearm, that is not a sensitive place because the government then is not protecting that location. And again, the Second Amendment protects the right, as this court said in Bianchi, to provide protection when the government cannot. And in these sensitive places, the notion that someone who would be willing to use unlawful force on another citizen or assassinate a government official is going to be deterred by an additional misdemeanor that would be incurred by taking a firearm into that place is absurd. And so the only thing that ties together the principles underlying the Second Amendment, the principles underlying this nation's history, is that a sensitive place is a place that a government secures. The schools are a separate issue. That is with respect to the school children. The government has in loco parentis authority over those individuals.
Let me ask you
Yes.
one question here as your time goes away. I had thought some part of the argument would go to the debate that's ongoing, and you can see in the other circuits' opinions a wide divergence of viewpoints on how we are to analyze what is the Second Amendment tradition. Is it tied to 1791? Does it go to 1868?
Mm-hmm.
Maybe you can give us 15 seconds on how you view that, because
Yeah.
that would seem to be fairly significant with some of the locations in this case.
So
Yes.
cover 100 years of history in 15 seconds as well.
It may take me a little
Maybe
longer than
20.
15 seconds, but I'll do my best. So our view is that 1791, the Third Circuit and Fifth Circuit got that correct. And the reason is the Supreme Court has held one thing with respect to this, and that is that it has to be the same with respect to the states and the federal government. Bruin was very clear about that. There are many other cases that are clear about that. So it can't be 1868 for the states and 1791 for the federal government. It's got to be the same. If that's the rule, it makes the most sense to say it's 1791 because that is when the right was adopted. In 1868, it was not a new right that was adopted. It just expanded the scope to which those rights attached. And so, for instance, if we have another state that was added to the Union today, we would say, okay, we're still either whether it was 1791 or 1868, we would still be using that version of the right. And I will submit, if I could have just a few more seconds, that it does not make a difference here, and that is shown by the Supreme Court's decision in Espinoza, where the court said that more than 30 state laws passed post-1868 couldn't constitute an early tradition. Here, they principally rely on 4 state laws that are post-1868. So these are not representative, they're outliers, and they can't establish an early tradition.
All right, thank you, Mr.
Thank you.
Patterson. Mr. Sweeney?
If you could start with the standing question that Chief Judge Diaz asked.
Yes, Judge Agee. On Joint Appendix 83, Susanna Kipke's declaration, she talks about attending the public library with her young children. And that's just the kind of example of the broad sweep of this ban on government buildings, where you have unsecured premises owned or operated by the government where carry has been banned. So I'd like to briefly talk about the public demonstration ban.
Well, are the plaintiffs required to allege standing with respect to each category of government buildings in the statute?
Well, Your Honor, I don't know that the standing cuts that closely, but we do have as applied as facial challenge. We believe that a facial challenge to a broad ban on government buildings under the principle of if the government provides comprehensive security at the building, it is a sensitive place. If they do not, it is not. On an
Well, I mean,
as-applied
that's-
challenge,
Yeah.
as an as-applied challenge, certainly we must establish standing for each category. Now, how you cut and slice those categories is subject, of course, to how you want to do it. But on public libraries, for instance, we clearly have standing on an as-applied basis. On a facial basis, we have standing to challenge all government buildings as sensitive areas unless they are comprehensively
And
secured.
have you made argument specifically on an as-applied challenge as opposed to a facial?
Well, we have in the sense that we have addressed the specific facts of specific plaintiffs in the briefs, but it is broadly a facial challenge, Your Honor. If I may address briefly the public demonstration ban, the judge below correctly enjoined the ban as being unsupported by historical tradition. There is no evidence of founding era bans on the carrying of firearms at public demonstrations, despite the fact that obviously they occurred at the time. We have challenged those, and we have standing to challenge those based upon, again, Mrs. Kipke's affidavit at JA 083, that she attends regularly, and would not leave the premises if ordered to do so but for the ban and the subject of criminal liability. The state has challenged her standing specifically on the theory that law enforcement have discretion whether or not to order an armed citizen to leave. But that argument, frankly, proves too much. If that were the case, there would never be a pre-enforcement challenge because law enforcement always have discretion. And in any event, Bruin said that the right to public carry cannot be premised upon law enforcement discretion. So we have established standing both facially and as applied with respect to the public demonstration. I see my time has elapsed. If there's no other questions in this complicated case, I will sit down. Thank you very much.
Thank you, Mr. Sweeney. Mr. Dietrich?
May it please the court, in Heller and then in Bruin, the Supreme Court affirmed that there are certain places, sensitive places, where the carrying of firearms may be prohibited. The state of Maryland, through longstanding regulations and now the Gun Safety Act of 2023, has stayed true to this nation's historical tradition, which ranges from the founding to Reconstruction and beyond. Although the district court correctly upheld locational restrictions at various locations, including parks, healthcare facilities, and government buildings, among others, the district court erred in striking down Maryland's private property default rule, as well as locational restrictions at places serving alcohol and at public demonstrations. Although this case asked this court to address various specific restrictions, which I'm happy to address on a case-by-case basis or otherwise, it may be helpful to address the larger question lurking in the background, which is, what does make a place sensitive? And to answer that question, we look to many sources. First, of course, we look to Bruin and its text, history, and tradition standard. We look that Bruin identified or
Of course, the
affirmed.
Supreme Court hasn't bothered to say anything other than sensitive places, so every court that has addressed this is sort of guessing at it.
Well, they're evaluating the clues that were left in Bruin. First and foremost is that Bruin in Bruin
There are lots
and
of clues in Bruin and Rahimi, and there's kind of one for whatever position you want to take.
well,
So you tell us about yours.
well, we start with Bruin. In Bruin, Heller, the Supreme Court affirmed that there is a concept and a tradition of sensitive places. So we start with that premise that they've already done the work for us in establishing that basic tradition. And then we look at the standard that Bruin talked about, and we look to Bruin's affirmation, as we've done here, of 5 exemplars of schools, government buildings, polling places, courthouses, and legislative assemblies. And looking behind those exemplars, we examine the particular historical statutes. Now, of course, in Bruin, the court did not rely on a plethora of statute. It relied on only a few to support the tradition that it identified. And we can look at the founding era, we can look at the Northampton laws that we inherited from our English tradition, we can look at the Reconstruction era
Well,
statutes.
the court was pretty specific in Bruin that they didn't think much of the statute of Northampton. In fact, they said it was irrelevant to what happened in 1791.
Well, I believe they were speaking of the statute of Northampton as the statute of Northampton, as opposed to the states that had adopted or inherited that as part of their English common law tradition. And looking beyond that to how that statute and that tradition had been interpreted and had been evaluated and evolved through the Reconstruction era. And we get to the statutes that the state is relying on that we put in our brief from Tennessee and Texas and Georgia, Missouri, and various local restrictions that are in the record that the state has put before this court. And we can talk about 1868 versus 1791. The state's position is that both of those dates are important. 1791 is obviously when the Second Amendment was adopted, but 1868 is when the 14th Amendment was adopted, which of course makes the Second Amendment applicable to the states. And in Bruin, the Supreme Court talks about that the rights are enshrined with the scope that when the people adopted them. And with regard to the Second Amendment, as opposed to the states, it's 1868. But we don't have to, I don't believe we have to parse through and say everything here is available and everything here is not available, and pick a date and to the exclusion of the others. I think what Bruin established is that there is a tradition that obviously started at the founding, or perhaps before the founding with American history, and evolves through that. And so that you have traditions that are in place at the founding, and that you have evolving technological changes, societal changes that inform the tradition as it evolves throughout Reconstruction and beyond. And what I think the takeaway from Bruin to this point is that they were evaluating the tradition of, or laws that restricted public carry wholesale. And what they looked at was that the laws that the state of New York had relied on that restricted carry wholesale were contrary to a prior tradition. And that's what made them invalid, was that there was a tradition and that those laws contradicted that earlier tradition, and that those laws were struck down contemporaneously with their enactment. What we have in this case is we have laws, Reconstruction era laws, that move with the tradition and restrict at particular places, like places, polling places, courthouses, the places of scientific and literary pursuits, public gatherings, racetracks, et cetera, the ones that we're relying on, the predecessors of Maryland's restrictions today.
Well, there are lots of racetracks in colonial times at the founding era, and there's no evidence that any of those restricted firearms.
I'm not familiar necessarily with the history of of racetracks at the founding, but
But it's your burden, though, isn't it? It's your burden to enlarge what sensitive places are, isn't it?
it's our burden to show the tradition, and we've done that through the record. And
But you're trying to enlarge it. You're going down the line. Judge Agee's question to you about race, you pivot from that, but it's your burden, isn't it? I mean, but the point is, Bruin was just incredibly broad. It would establish that, from the Heller, that people have a right to protect themselves and carry weapons. I mean, that's what we have to construe by what the Supreme Court said, and saying we go back to 200 and some years to figure out what these analogs are, and they were pretty broad then. People carried guns in many places. So the question is, you're broad in why is it sensitive? I guess that's the question is, and your worthy colleagues on the other side say it's sensitive in a sense because maybe these places shouldn't be, they're places where there's no protection, then public has a right to protect themselves. And those are places that are where you assume that there is protection by the government, there's no need. Why is that not a sound scenario to understand Bruin? Because it's very difficult to understand Bruin, but we have to do that. But we do, it's a look back. It's not a look present, it's a look back. And they did name these things, but I don't know what sensitive is, but tell me how you're using the sensitive to broaden it and being your burden.
Well, one point that I want to get out is that
Like going to the baseball game, for example.
right, and baseball, as far as I know, was invented in the late 19th century and wasn't around at the founding.
But games they played lacrosse and all those kind of things like that. They're old games.
Right,
Right?
and the way that personally I think about it is, what would James Madison think? Would James Madison have tolerated?
Be careful, James Madison didn't have Bill of Rights at all. It was Jefferson who persuaded him that every country has to have a Bill of Rights. They were finished in 1787, in September 17th. It was later on that they came on the Bill of Rights. So we don't know what Jimmy would have said at all.
Now, there are times I kind of wish we could sit down and talk with him and Jefferson. What in the world would the two mean here?
Right.
I wish as well.
You invoked the wrong name there in terms of the Bill of Rights, because they were done. They were finished. They only did that because they had to do it because people like Shays Rebellion.
Well, he may have had to do it, but he incorporated the words and.
But he had to do it because the pressure was the people who had Shays Rebellion said, look, we have a government, but we want to make sure we can have weapons and just in case that government turns on us and that we're able to. I mean, you have to read the broad thing. The Supreme Court sort of read out the militia part of it, saying it's an individual right. but words mean something in that sense. But going back to, how do we do that? How do we? you
Bruin
could list
talked about a nuanced approach to places that were not in place in their modern form at the time of the founding. So we're talking about stadiums, museums, healthcare facilities. I understand my friends on the other side can point to a few museums or a few racetracks or some gambling facilities at the time of the founding, but they weren't prevalent, and they weren't in the nature that they are
Oh,
today.
there were lots of gambling houses at the time of the founding, just like places of alcohol. Nobody had to check their gun when they went into the Raleigh Tavern.
But also think about the nuanced approach goes also to what this court talked about in Bianchi, which is the evolution of the types of weapons that were available. At the time of the founding, most guns were long guns. They were muzzle-loaded muskets. They had to be loaded to be available for confrontation.
But you know what the commonality is? They were all lethal. They were all lethal, weren't they?
As far as I,
Yeah, they could kill a person.
right, but they couldn't be carried loaded.
That's the only thing you're worried about as a human being, right? Whether or not you're killed, I mean, whether it was a smooth bore or whatever it is. They had weapons. They're different, but they're all lethal. That's the commonality of it. And
But
Bruin says we go back to the times when lethal weapons could be used to protect yourself.
But they couldn't be carried for long times, loaded. They couldn't be concealed. And so when these types of weapons, as this court talked
So
about.
you think if somebody went into the Raleigh Tavern with a Derringer, that was a burden to them? And they'd already put the shot in, they'd already put the powder in, all they had to do was pull back the lever and pull the trigger.
I think that was a burden on,
Well, your point, I thought, was that, these were predominantly long guns. Well, I don't know how many people carried a long gun into the Raleigh Tavern, but I bet there was a whole bunch of them in there who had pistols of some sort.
and from my understanding, the pistols of that era were the same type, where they couldn't be carried loaded because of the issues of gunpowder, corrosion, and that only in the early 1800s did the weapons develop to a point where they were both concealable and they were ready for confrontation. And that's what motivated a lot of the laws with regards to weapons restrictions that this court faced in Bianchi, as well as the laws for sensitive places, for taking into ballrooms and museums and places of social and literary and scientific purposes. And I know I've discussed a lot of this in the brief, and I see that my time, as I expected, is getting low, and I'd like to talk a little bit about, first of all, to the comprehensive government security standpoint or doctrine. I believe that that's terribly ahistorical, in the sense that Bruin in the Supreme Court and Heller talked about polling places, for example, and used polling places as an exemplar. Clear guidance to states to say you can ban people from carrying guns at polling places, but not so under the theory proposed by the plaintiffs, because it's only if there's comprehensive security. Yet there's no comprehensive security at polling places in Maryland and at places across the country. So what was a clear, what the Supreme Court apparently says is a clear, sensitive place is not so under that theory. And it's terribly ahistorical, because now you can take a place that is not a sensitive place or would otherwise not be a sensitive place, but make it a sensitive place. And my friend on the other side used the McDonald's in Pennsylvania. And I think that gives away too much, because what it says is that any place can be a sensitive place at any time, so long as the government provides comprehensive security, which completely blows out of the water their facial challenge, because you certainly can imagine that any place could be given government comprehensive security, and ipso facto, it's a sensitive place. But going to the particular locations that the district court struck down, first with regard to the public demonstration statute, this is not a statute that prohibits firearms at public demonstrations, firearm carried at public demonstrations. Under a normal statute, if it was a prohibition, someone could if someone carried a firearm at a public demonstration and nothing happened, they could later be charged with that conduct. If a police officer saw someone carrying a firearm at a public demonstration, they could be arrested on the spot. But under this law, a few things need to happen. The police need to see a firearm, which is sort of contrary to the whole concealed carry regime. And then they need to tell that person that, one, a public demonstration is occurring, so there's notice. And then they need to tell the person that they have to leave and put the gun away. And so under this statute, there's no, the idea that someone is going to be charged with that is entirely speculative, and standing falls away. Of course, on the merits, we have the tradition of prohibiting firearms at public gatherings that are in the Reconstruction statutes that we've identified in the record. On the places that serve alcohol, I'll just note that the other two circuits that have addressed this issue, the Second Circuit in Antonyuk and the Ninth Circuit in Walford, have said that there is a tradition of restricting firearms.
Well, I think at least one of them, maybe both of them, said, well, it's a sensitive place because you have intoxicated people there. And I don't think there's any founding era support to say that, well, we're going to ban firearms in an area where there are intoxicated people. They might ban the sale of alcohol, but, I mean, there were bars everywhere in the founding era, and some of the people in there were drunk, but
Sure,
there's no
and-
prohibition on firearms at that time.
And so I think what's at play is not only Bruin's nuanced approach for the history that's developed in the interim, but also they identified a tradition of restricting of the deadly mix between firearms and alcohol. And they saw that in founding era statutes that restricted the militia from selling, and I see my time is up.
You can answer the question.
So I'll just identify or speak on the tradition that's developed in our brief and that was relied on by the Ninth Circuit and the Second Circuit. Founding era laws restricting sales of alcohol near the militia, Reconstruction and antebellum laws that restricted the storage of gunpowder in places that served alcohol, laws that restricted intoxicated carry, and finally dead ringer statutes from various jurisdictions that actually prohibited the sale of alcohol or prohibited the carry of firearms in places that served alcohol.
Thank you very much.
Thank you.
Mr. Dietrich. Mr. Patterson? Yes, sir.
Thank you, Your Honors. I'd like to start with this point about nuance. We don't think this is a case that involves nuance. There's been places from time immemorial of public gathering, public recreation, and there weren't bans there. But to the extent this were a nuanced place, that supports us for all the reasons my opposing counsel states. Firearms are more concealable. They're deadlier. That means people's need for defense is enhanced, and that the government has to do more to keep a firearm out of a place now and actually secure it than they did at the founding. So that's why at the founding, they had things like doorkeepers and sergeants at arms at legislatures. Today, they have the metal detectors we needed to get into this court. And so that's what the government needs to do to make a place secure and to acknowledge it as sensitive. And this really goes to the heart of what the Bruin analysis is and what it said with respect to founding era laws restricting firearms at polling places, courthouses, and legislative assemblies is that we can analogize to those laws. The court wasn't saying that every single instance of those locations is sensitive for all time. It was saying we can analogize to those laws at the founding that restricted firearms at those locations and apply those principles today. And polling places is actually a good example of changed circumstances. We didn't used to have a secret ballot in this country. So there was a big problem with armed intimidation and other tactics trying to get people to vote a certain way. And that was why we had sheriffs operating those polling places. As we've shown, they're secured. That's why I believe it was in Delaware where there was a restriction on firearms at or near polling places. But now we have the secret ballot, so that same risk is not present today. And if the place is then not secured, then it's not a sensitive place today. And so that is our analysis goes to the heart of what Bruin says is, and Rahimi too, we apply the principles. We don't apply the application of the principles at the founding. We apply the principles to today's facts. And also the founding era law restricting firearms at courthouses I think is very instructive. That was the Virginia Northampton analog that the Supreme Court said the 1786 law practically codified the common law. And the common law is a generally applicable law, so we should say, okay, this is a very representative statute. And what that statute did is that it banned only terrorizing carry in most places, as Bruin held, in fairs and markets and other places. But the first part of that statute said nobody can go armed to courts except the judges and those assisting them. The founders were not fools. They realized that in a sensitive location, we can't put up a sign, enact a statute saying no firearms. If a place was going to be sensitive, the government protected that place, and that is a very clear and objective standard to apply to today. And then I'll say a word about the facial versus as applied issue. By saying it's security, we are not giving away the facial challenge. Heller was a facial case, and it said the ban on handguns is facially unconstitutional, even though there are some firearms, if it's possessed by a felon, that can be punished, or a violent felon at least, and also if it is an automatic firearm, if it's an automatic handgun, Heller suggested that those could be banned, but that didn't get in the way of the facial challenge, and the reason why is the reason why a firearm can be banned is at a, for example, a courthouse, is not because it's a courthouse, it's because it's secured. And so that is not in the statute. So the statute, again, putting the face of the statute next to the constitutional analysis, there's no application in which it is constitutional. And even if there were, the distinction between a facial as applied challenge is not of some talismanic significance. As the Supreme Court said in Citizens United, it only goes to the scope of the remedy.
How does that apply to schools? Let's say schools don't have security necessarily. I mean,
Well, schools are a different principle, Your Honor. As I explained, it's in loco parentis authority. That's what the history shows. All of the historical bans of firearms at schools were bans on students carrying firearms, reflecting the in loco parentis authority that the schools had over students, as explained by the Fifth and Eighth Circuits in Worth and Reese. And if Your Honors don't have any additional questions, I ask that all of the bans be invalidated. Thank you.
Thank you. Mr. Dietrich?
Thank you, Your Honors. I think that, I forget who made the point, but I'll make the point again, which is with regard to all of these principles that the plaintiffs have explained, why didn't the Supreme Court just say so? If it was government comprehensive security that was the animating principle for government buildings, courthouses, et cetera, they could have just said so and settled this debate once and for all easily. If the school, the animating principle for schools was the in loco parentis doctrine, they could have said so very easily. They didn't. They said it unqualified, and therefore that those principles that my friend from the other side advances should be rejected.
I mean, well, there have to be some qualifications. I guess the example that was in Bruin or perhaps elsewhere was you can't suggest that the whole island of Manhattan is a sensitive place and therefore ban guns in Manhattan, right? So there's some limiting principle, and I think we're still struggling to figure out what that is. So can you help us?
Well, I would point to that example as very instructive in the entire debate, because if New York, apparently, they took New York as in Bruin as trying to make Manhattan, because we all know Manhattan is a very discreet, crowded place as things go, that they wanted to make, they say we can prohibit guns there, carriage of firearms there, because it's so crowded and it's a sensitive place, just like you said in Heller, sensitive places. And Bruin pushed back on that and said, no, that's getting it too broad a brush of prohibiting firearms. But they could have, but that was the extreme. New York was sort of taking the extreme view of saying that you could make a whole island, a whole city as sensitive. But the Supreme Court could have rejected that out of hand and said, of course that's ridiculous, because there are only these small parts, these very few places that are sensitive. Instead said, oh, well, you can't make a whole island sensitive. So we are not trying to make the entire state of Maryland or the city of Baltimore, any place within Maryland, a sensitive place. These are discrete places that are supported by the historical tradition.
But when you talk about sensitive, can we just use the word itself, sensitive? Is it, you know, Heller already said you have a right to protect yourself, right? And it has nothing to do with any situation about how many people in America kill, you know, people, homicides and things like that. That's out of the question. It said regardless to all of that, you still have that right. But the sensitive kind, what's sensitive? Is it because that's a place where you sense fear? What do you sense? The root word is, you know, sensitive is sense. What is the sense in that place that would narrow the right to carry a gun? What is the sense you're protecting?
Well,
The
one thing
person who might be shot by you, or is it that? What is it? I mean, because I think that's where you really should start. Since the Supreme Court left it vague, you leave with the words they used. They said sensitive. You didn't say protective places, as they would say. But what is it? What is it? What do you think there? Help us with that. What does that mean?
I think if we can go out to a wide angle, I think it's places where firearms and are not compatible with either the type of place that it is, or the people that are there, or the activities that take place there.
That means
but-
a place where you don't have to fear for your own protecting yourself.
But I don't think that's part of the analysis. I don't think
Well,
that's
why wouldn't it be? Because that's what we're talking about. We're talking about the right to protect yourself. Sensitive places are places where you lose that right to protect yourself, correct? Because that's the whole point. I'm not being philosophical. I'm talking about this. I'm trying to find some sense of what the Supreme Court has done in these cases. They're saying you have a right, but we carve out what's sensitive. Is it sensitive because there you don't need to protect yourself? Or you might wrongfully
I think
hurt
this is-
someone else? What is it? If we get that, I think we could start understanding rather than trying to be creative. Let's deal with the word that the Supreme Court gave us. It said sensitive. So sensitive must relate to the right that you had. The right was to protect yourself. So this is a place where you don't need to protect yourself. That seems just as logical as anyone I've heard, because otherwise it's not sensitive. I'm scared when I go there. I need a weapon there. I mean,
But I think
right?
that's where you can use schools as a good exemplar for, you know, if you want to go to your child's school,
Right.
and they say you can't bring a gun in, do you have to say, well, I need there to be magnetometers and armed guards everywhere because I have forfeited my right to carry a firearm? And I see my time is up. If
No,
I may
please answer.
continue. That's an exemplar of a place where you give the firearms restricted because you don't want firearms in that place. Even if you were confronted in a way that you might otherwise use a firearm, that would be incompatible with the space and the protection of the people there. You don't want people shooting and in a subway car. You don't want people shooting in a crowded ballroom. You don't want people shooting in a museum. Things of that nature.
Why not? Why shouldn't you shoot there to protect yourself? If someone on a subway pulls a gun and want to kill you, that's when you need one. I don't understand that. I mean, that's when I need one. I'm confronted with a whole lot of people I don't know anything about them. They can jump on and off a train. That's where I might feel. I'm trying to make some logic to what the Supreme Court is saying. That's when I need one. It's based on the need and the right to protect oneself. That's what they said. That's what the Supreme Court said. So we're not talking about, why do you mean it's sensitive? Yeah, that's what I needed. I don't need it, right? That's what we're saying. I need a weapon so I can shoot someone when I needed to protect myself, not unlawfully, not as a marauder, as a defending. So you're saying, look at the subway people being pushed on the rails. Rapes and muggings. That seems like a place you would need a weapon. Why not? Why not? Tell me that. Why not? These are the places where people get killed. They're robbed in parks. You're sitting there trying to read the newspaper, enjoy the birds, and somebody comes along and mug you. Seems like a place that's where you need a weapon.
Right, well, the state in its police power has decided that weapons are incompatible with those places, and that's the way that the state has decided to
Police
keep.
power. That's the whole idea about by the Bill of Rights. It's to protect us against police power when it overstates a right that's ensconced in the Constitution. It's the second one, too, way before the Fourth Amendment, way before the Fifth Amendment, Sixth, all these powerful. That was second only to the right to speak and to assemble and press. The next was, I mean, you got to read it as it is now. You can't wash away because you disagree with it. That's what they found when they did. They said, no, boom, we need this one right here.
I see
You
my
don't
time
need to
is,
respond.
I see my time has expired. I'm happy to stand up here for as long as needed, but if not, I will
Yeah, you may
rest
be
on my
happy,
brief.
but we're not.
No, no.
So,
Thank you, Your
very
Honor.
much.
That's, who knows how long the next one, we'll take it short.
All right, I want to thank all of the council for their fine arguments in this really difficult and challenging area of the law. We have yet another round coming up, but before we get to that, we're going to come down and greet you and then take a brief recess.
This honorable court will take a brief recess.
Warm up for the Supreme Court, so you have to take some of these.
All right, please be seated.
Our third and final case is 24-1886, LaFave versus the County of Fairfax, Virginia.
May it please the court, good morning. I'm Stephen Holbrook, representing the appellants. Fairfax County has about 24,000 acres of parkland, public parkland. It entails 335 or so miles of pathways, and it constitutes almost 10% of the county. Fairfax County saw fit to ban mere possession of firearms throughout all the public parklands, and also in places that require a permit for a public gathering but don't have a permit, and in adjacent places to those places. So,
So you raise a facial challenge here.
yes,
Is
we
that
do,
correct?
Your Honor.
All right. So a distinction from the prior case, which I'm sure you were listening to with regard to parks, is, as I understand the record here, the county operates 3 preschools in county parks. And if the school restriction the Supreme Court cited several times applies, why wouldn't that in and of itself end a facial challenge with regard to parks?
Because the park ban is separate from the school issue in the sense that it's already
Right, but there
illegal.
are schools in the parks, apparently.
The
That's my point.
firearms are banned in those places because they're schools separately. And the ordinance cannot be so broad, though, that it would encompass these tiny places. We're talking about mostly wooded areas. And the county would be free, actually would be redundant to pass a ban on guns in those small
Right.
places that have
I understand
schools.
that argument, and it may very well be a valid as applied argument, but from a facial standpoint, when you're challenging parks in toto, if there are places in the parks where the banning of firearms is appropriate under the Supreme Court's rulings, that's where it seems to me there's a real problem in a facial challenge, because the courts adopted the Salerno principle in terms of Second Amendment facial challenges.
There's two different kinds of approaches we can take to this issue of whether something is valid or invalid in all circumstances. Salerno and Rahimi. And to speak to the Rahimi situation, for example, you have founding era precedent, namely the going arm statutes, that justified banning possession of guns by people who are found to be dangerous and found to be a credible threat to another person. The same with Salerno. That was a mob case involving the Bail Reform Act. And so we're talking about people, not a substantial area of constitutionally protected conduct. But if we contrast that approach with, for example, Bruin, there are plenty of sensitive places in Manhattan. But like the court said, you can't ban firearms throughout all of Manhattan. I like to think of the example of the Thurgood Marshall United States Judicial Center. I've argued cases there, and beside that is the New York County Judicial Center. Those are sensitive places, not to mention all the schools throughout New York City, Manhattan specifically. But you can't ban guns in the entire jurisdiction of Manhattan. So I think you can certainly ban guns in places that are sensitive places, and that's why, as I said, it's already illegal to have guns in those school properties that are within the boundaries of the park. But we're talking about mostly wooded areas, and the fact that our plaintiffs are people with Commonwealth of Virginia issued concealed weapon permits. They go in these mostly wooded areas. There's no protection. And if that's a sensitive place, then there's no end to sensitive places. So what I'd like to turn to is, first of all, we start with the Bruin standard. There's a presumption that if something is encompassed within the plain text of the Second Amendment, that it's protected. And that's what we're dealing with here, the right to keep and bear arms. And it's up to the county to find analogs from the founding period. What the county has done is to depend primarily on the Second Circuit Antonyuk case, and they try to argue that Virginia and North Carolina had analogs to banning mere possession of guns in certain places. So the Virginia statute, however, this is from, I think, 1786, provided that going or riding armed,
The Supreme Court refused cert, I believe, in that Second Circuit case, didn't
there's an Antonyuk 2 case now, but what the Supreme Court did was to grant cert, vacate, and remand for further consideration in light of Bruin. In light of Rahimi. And so the Second Circuit did that, but and I'm going to call it Antonyuk 2, it adopted exactly the same reasoning as before.
And they didn't file cert and
The status of that case now, I'm not sure of. It's, I think there may be a cert petition pending in that.
All right, well, we can find that.
Can I ask
Yes.
you about the expert affidavit or declaration of Professor Cornell that talks about the history of parks and the notion that parks at the founding weren't really parks as we think of them today, or even when parks became a broad aspect of our culture and society, and that at least from the founding of parks in the sense of which we describe them today, that weapons were always banned. Why isn't that enough to support the ban in this case?
Well, first of all, there's always been green or common places where people did things like contemplate nature, and children played, and there was Boston Common from the 1600s. There was the National Mall in Washington.
Right, but I guess the evidence of record suggests that was more of a place where militia were to be found, where weapons were stored, where cattle grazed, but not the kind of place that we think about in today's society, or in the late 19th century, that we think about when we think about parks.
What Professor Young said is this romantic idea of contemplating nature somehow made these places very different. If we want to start with Central Park in 1858, it was enclosed. You had to go through certain gateways to go in. There was security there. It was quite different than vast parklands. And it seems incredible to think that the vast areas where people could recreate and where we've documented in the record that people did a lot of the same things that you do in parks today, it just baffles the mind that there's some kind of revolution in doing away with Second Amendment rights in these places. The county has, and Professor Young or the county, they've not identified any specific security threat that people have in places where there's a romantic idea of contemplating nature, and humans are the same. Whether we might have enhanced parks, but we still have, before we had Central Park in New York, we had other places where people would recreate, and just because they did militia activities there, or maybe graze some cattle, didn't make any difference. Also, these, as the county piles up these ordinances and makes it look like a big quantity, there was only Central Park before the Civil War, and then I think Philadelphia might have been 1868, and that too also, I believe, had enhanced security. And then we move on to going into the latter part of the 19th century and then into the 20th century. These are the examples that the county gives, but that's too late. And you've had the discussion a few minutes ago about 1791 versus 1868, and it's our position that 1791 governs. You've got the fact that all of these federal cases that were decided involving the federal government and the application of Bill of Rights guarantees to the federal government, you can imagine the mess it's going to be if suddenly 1868 is the standard that we go by to evaluate restrictions that the federal government might make. My colleagues may actually make that argument in their brief that 1868 would be the year or the public understanding date that you would look at for even federal restrictions. And I think it's impossible to think that you're going to have one standard for the feds and another one for the states. And what the court has said consistently in Heller, Bruin, and in Rahimi is that we look at the original public understanding, and for later precedents, analogs, I should say, we look at what is consistent with that earlier understanding. And so, getting back to the analogs, if I could return to the two analogs that Antonyuk II cited, Virginia and North Carolina, that court was just simply wrong about them. Virginia, 1786, made it a crime to go or ride armed in markets, fairs, and other places in the terror of the country. So there was the terror element that had to be proven. In North Carolina, in 1741 and again in 1791, there was a statute providing that constables had to arrest people who would go armed offensively. And in both of those statutes, they also said that as far as slaves go, if they go armed at all, that was a crime. And so you can see a clear distinction between going armed offensively and going armed at all. And yet the county tries to argue they don't even recognize those two laws were on the books. They instead want to use a privately published compilation of English statutes that were passed by Parliament that the author claimed were enforced in the states. The collection by Francois Xavier Martin, a collection of statutes to the British Parliament. That was never a law passed by...
I'm sorry to interrupt, but that's the problem with this whole exercise is whose history do we accept? You've just gone through a summary of why you think a historical record is somehow different from what the other side suggests, and it's just not clear to me how we're supposed to figure that out.
Well, because in the case of North Carolina, we have what the legislature actually passed in 1741 and then in 1791 versus this private publication that Antonyuk II claims was the law in North Carolina. And all it was a reprint of the Statute of Northampton that the Supreme, actually if you go back to English precedents, and Bruin talks about these English precedents, that was never interpreted to mean that going armed per se peacefully was an offense. And in fact, what the court said, the common law offense was simply to go armed in a manner with, to terrorize other people with dangerous and unusual weapons. And so, again, if we're talking about the county, we have the fact that these are large forested tracts of land throughout the county. If you go on these trails, you could be, our lead plaintiff, Ms. Lefebvre is a single female. She's walking on the paths by herself. There's no security out there. And I don't need to go into, there's been crimes committed in these park areas. But as far as the need for self-defense, I think Judge Gregory's comments in the previous panel are highly relevant here. What's a person to do? Anybody can go out there with a concealed weapon. You can't restrict that. And for the county to make it a misdemeanor for a bad person to go wait for somebody to potentially attack a person for rape or robbery or whatever the case may be, and to say that person needs no security, but the bad guy will be deterred by this misdemeanor prohibition, I think it's just so totally unrealistic. But I think the bottom line is not the policy arguments. I think the bottom line is what Bruin has set forth in terms of There's a presumptive right to bear arms. There's got to be some kind of overcoming of that presumption by the government. And in this case, they failed to do that. There's no historical analogs. And even if we want to start with the too late purported analogs that they talk about, there's not enough of them. We have one city before the Civil War, and then we have the increasing number of local jurisdictions adopting park restrictions. And bear in mind again that these parks were enclosed and they had doorways and they had so-called keepers. That's in Dr. Young's affidavit, the people who provided security. And so those precedents just are not like the parks today. And so we think that the court should look at this case in terms of, here we have these huge wooded areas, and if you can ban guns in those, and if that's a sensitive place, there's really no end to this. So I see my time is up unless there's a further question.
Thank you, Mr. Hallberg.
Thank you.
Ms. Carter?
Good morning, and may it please the court. I'm Janet Carter, representing defendants. This court should reject plaintiffs' facial challenge to Fairfax County's restrictions on guns in county parks and at county permitted events. Their facial challenge to the parks restriction fails because banning guns from parks is consistent with historical principles and in fact precisely matches well over 170 historical laws from all across the country. And just like the other sensitive places laws that Bruin recognized as consistent with the Second Amendment, there have been no disputes regarding the lawfulness of banning guns from parks historically. No treatises, no case law, no commentary suggesting that these laws were ever considered to be unconstitutional.
So, but what do you have before 1868?
So we've identified 3 strands of historical laws, and I can go through those in turn. The first are prohibitions on guns in schools, and going to your point earlier, Judge Agee, about this being a facial challenge. The many small playground parks in Fairfax County are ones where guns can obviously be banned by analogy to the constitutionality of prohibiting guns in schools. Now, my colleagues in this case, they haven't challenged that.
Your colleague makes the point that, you take the preschools out of it, most of the park area is, wooded area. I mean, it's not a playground or anything like that. I mean, so if the schools weren't involved in this, why would you prevail?
I'm not referring, although that is also an important part of this case, is that there are these preschools in 3 of the parks.
Right, I understand that, but let's just assume the schools weren't there.
Yes, I'll put those aside. There are parks that are just a playground. Farrington Park, it's not much larger than this courtroom, it's just a playground. Clemejontry Park, it was designed for kids with special needs. There are a large number of small playground parks, and plaintiffs' position, because they have chosen to bring a facial challenge, what they need to prove is that this law is unconstitutional in all of its applications. That's what the Supreme Court said in Rahimi. And there are these numerous applications where the law is clearly constitutional. So they can bring an as-applied challenge if they want to challenge the more remote parks, but that's not what they chose to do. And I want to be very clear. We have assembled a historical record that establishes that the county's regulation is constitutional in all of its parks, because not only have guns been prohibited from urban parks, they've also been prohibited from state and national parks, again, with no disputes as to the constitutionality of those prohibitions.
Well, the discussion seems to have been sort of limited in their historical analysis. to Boston Commons and the Washington Mall, but there were lots of other green spaces in the founding. I mean, there were at least 3 in Colonial Williamsburg. You can see them today. At Hampstead Mall and Charleston, and there's no evidence that there were any restrictions on firearms in any of those places.
So this is an important question that also came up in the last argument about historical silence. I want to answer the first part of your question first, which was about whether those early green spaces are properly considered parks. We have uncontested evidence from our expert witness, Professor Young, that parks at the founding, those early green spaces at the founding, they were set aside for utilitarian purposes. They were shared grazing pastures or dumps, or they were used for militia training. They were completely different
Well, the
from
militia
what
might have
emerged.
trained once a month, but are you going to tell me that all the people in Charleston, South Carolina who went for strolls in the Hampstead Mall in the founding area were prohibited?
So this gets to the second part of the question, but I do want to underscore that the record here is uncontested, and both Wolford and Antonyuk held, and to your question about Antonyuk, cert has been denied from that second iteration of the cert petition in Antonyuk. Both of them found that parks did not emerge until the middle of the 19th century. But even if you disagree with me about that, that doesn't mean that the absence of regulation at the founding rendered regulation unconstitutional. This has been made clear. It is a fundamental premise of federalism that governments don't regulate to the constitutional limit. Governments are allowed to experiment with regulation within constitutional bounds. We saw in Rahimi that the Supreme Court gave no weight to the fact that even though domestic violence has existed since well before the founding, and even though there were no laws specifically disarming domestic abusers at the founding, it gave no weight to that fact in its analysis, and in fact had no trouble concluding that the law that was challenged there was constitutional. The Supreme Court in Dobbs, the day after
Well, they
it
didn't do that in a vacuum. I mean, they did it because of the riding in terror of the people laws.
in Rahimi.
Right.
Yes, so the court drew together 2 strands of laws that were quite distinct from the one that was challenged. As Judge Rushing's concurrence in the judgment, I think, in the Maryland shell issue case made clear, there was an enormous, and indeed Justice Thomas's dissent in Rahimi made clear, there was a very large distance between the law that was challenged in Rahimi and the analogs that they relied on as sufficient. So again, the question that this goes to is the fact that silence on the particular question at the founding is not dispositive. So even if I were to grant that those early green spaces were parks, again, contrary to the record and contrary to Antonyuk and Wolford, nevertheless, all of these sources, and there are more, so Dobbs decided the day after Bruin, said the fact that many states didn't prohibit pre-quickening abortions in the 18th and 19th century didn't mean that anyone thought that they lacked the authority to do so.
I
Justice
understood
Barrett.
sorry to interrupt, Ms. Carter, but I understood your colleague's argument on the other side to be not that there was legislative silence, but that to the extent that the founding era legislated, it was there were restrictions, but they were limited, as Judge Agee described, to people riding to the terror of the populace, and therefore that's sort of the history that we look at, not silence, but the specific limitations that were in place at the time.
So that is a regulation that existed as to carrying guns anywhere. It's not, that is not about, that part of the statute of Northampton is not about sensitive places. Northampton and Northampton-style laws from the early American states did 2 things separately. They prohibited guns in particular places in front of the king's justices in Northampton, or in front of the justices,
Thank
i.e.
God
in
for
courts. Excuse me?
Thank God for that.
And also in fairs and markets. And then they also prohibited guns elsewhere. And it was that second part that had the terror
So where was
requirement.
the elsewhere?
Anywhere. So if you carry guns anywhere to the terror of the people, that was prohibited. That's what Bruin
Right, but
said.
the Supreme Court in Bruin said, you know, that the statute of Northampton, to the extent that it would make a per se possession in a fairer market precedential, had no application come 1791. I mean, they're pretty clear on that. And so what they've used is, you know, solely, to a certain extent, surety laws, which really didn't disarm anybody, or these riding to the terror laws. That's what the Virginia and the disputed North Carolina statute were about, were riding to the terror, not a per se possession of a weapon.
So I think that the Second Circuit in Antonyuk was correct about this, that Bruin has not decided anything about the parts of both the Statute of Northampton, but I think more importantly, as my colleague from Maryland said, the early American laws observed in North Carolina and Virginia. They haven't said anything about the part that's about the specific carry locations, fairs and markets, and courthouses,
Well, they
everything.
probably didn't need to, because that hadn't been the law for 300 years. I mean, ever since Sir John Knight's case, 1686, you know, you had to be riding to the terror of the people.
Well, again, that's elsewhere. The colonial law, so Virginia's law specifically.
Right, which Bruin specifically discussed.
I don't believe that Bruin discussed the Virginia iteration of it, particularly as it applied to these particular locations. I would like to get to a number of other arguments that we've heard. One of them was the question that you asked Judge Agee in the previous argument about 1791 versus 1868. Now, this court, we submit, should just look at all of the history across time, as it has done in Bianchi and as the Supreme Court did in Heller and in Bruin. But if it decides that it wants to address this question of 1791 and 1868, I just do want to make sure we're clear on just how strong the arguments are for 1868. This is what leading proponents of originalism have said is the correct answer in cases against a state or local government, as this case is, and the Maryland case is. Because the question that an originalist is answering is, how did the people understand the right at the time that they adopted it? And the right to keep and bear arms was only adopted as a constraint on the states in 1868. So many leading commentators in academia have said that. It's also the position that Justice Thomas took in a dissenting opinion in Mahanoy Area School District. He said in that First Amendment case, "I would begin the assessment of the scope of free speech rights incorporated against the states by looking to what ordinary citizens at the time of the 14th Amendment's ratification would have understood the right to encompass." Justice Scalia said something similar in a case called McIntyre from 1995. And even the NRA's lawyer in Bruin was asked this question by Justice Thomas. Should I look at 1868 and Reconstruction, or should I look at 1791 and the founding era? And he said, if the case arose in the states, I would think there'd be a decent argument for looking at the history at the time of Reconstruction and giving preference to that over the founding. So all of these...
Third Circuit didn't seem to buy that argument in Lara.
So
Was that wrong?
We do disagree with Lara. That's also distinguishable because, unlike in this case, there is positive law in the founding era that the court considered to be in conflict with the later law. Here what we have is no regulation at the founding, and I've told you all the reasons why no regulation of carrying guns in early green spaces shouldn't be considered a indication that anyone thought that that was unconstitutional. As Justice Barrett said in her concurrence
Well, there
in
wasn't any
Rahimi.
regulation in the founding era as to, I mean, and obviously the Supreme Court's going to have to figure this out, as to the 18-year-olds carrying firearms. I mean, there wasn't any regulation for that. Most of them had to show up for militia service and bring their own weapon, and I guess you could deduce from that there wasn't a regulation, because you could also argue, well, the only place they could carry the firearm was to their militia duty.
The Third Circuit understood those early militia laws to be establishing not only a duty, but implicitly a right, because if they had to show up at militia duty with a gun, and given the militia context of the Second Amendment, they considered that to establish some right. We disagree with that, but that's how the Third Circuit got to the conclusion, I believe, that there was positive law at the founding establishing a right for people in that age group to carry. We don't have anything like that. Again, Justice Barrett in her concurrence in Rahimi said it would be a serious mistake to say that historical silence had that kind of implication, because governments don't regulate to the constitutional limit. They don't have what you described as a use it or lose it approach to regulation. I want to also speak to the question that Judge Gregory asked about going to this government security argument, and I want to quote from the en banc decision in Bianchi. I realize that two members of this panel didn't join that majority opinion, but nevertheless, it is the en banc decision. I'm quoting, "Another limitation from Bruin involves where arms can be carried. Laws forbidding the carrying of firearms in sensitive places such as schools and government buildings are permissible." Quoting Heller. Continuing the quote, "Again, citizens in those places have no less of a right to protect themselves, but our society has deemed that giving people the capacity to use large amounts of force at a moment's notice in a sensitive place is not worth the danger that they will unlawfully deploy such force against innocent civilians or public figures there." So this speaks, I think, to the fact that the government security argument that is somewhat advanced in this case and much more advanced in the Kipke case is completely incompatible with what the Supreme Court has said about sensitive places. Government buildings today routinely lack security. Schools routinely lack security. Polling places do. It's absolutely clear that the Supreme Court thinks it's permissible today to ban guns in polling places. But my friends arguing for the Kipke plaintiffs are saying that the government can't do that unless they comprehensively secure a polling place as if it was the entry to an airport. Several states actually prohibit that because of concerns about voter intimidation. You can't have that kind of security at a polling place. And so it's impossible to reconcile that argument with what the Supreme Court has said.
Well, if you accept the premise that the Supreme Court has just put schools and government buildings as categories, they're off limits to guns, end of discussion. How does that help you with any of your, because they're identified by name, and there's no, as I think our questions have illustrated all morning, there's no real principle that flows from that that's clearly identifiable. You got schools, you got government buildings. How does that help you with your arguments?
So I disagree that there's no principle that flows from those. With respect to schools, I think what's going on there is a recognition that there's a principle that you can prohibit guns to protect a vulnerable population, specifically children. When you have a playground park, a small area that's just a playground, the exact same interests are in play. But nevertheless, I think a very important fact here is that the Supreme Court was very clear that it was not setting out an exclusive list. It said, for example, both in Heller and then in Bruin, when it set out its sensitive places discussions in both. And we have now gone and found well over 150 historical laws specifically prohibiting guns in parks. What those decisions were asking for was that historical analysis. Either you can reason by analogy from places that the court has already identified, or you can go out and find historical laws. So even if there were any doubt about the analogies that can be drawn from the places that the Supreme Court has already identified, there's no doubt that prohibiting guns in parks has been considered constitutional from when those parks first emerged in this country until today. Again, with no earlier conflicting evidence, and at no point in history any indication that anyone considered those laws to be unconstitutional.
What about the events? I mean, that's pretty broad, isn't it?
So it's not broad, and thank you for that question. It's not broad because of how it operates in Fairfax County. It only applies when there is a county-issued permit. This is something that plaintiffs' briefing repeatedly omits. It has to be a county-issued permit, and because the county doesn't own its streets.
No, but it doesn't, it says broader than that. It says, it applies to any place whatsoever in nature that's open to the public and being used by or adjacent to a permitted event or an event that would otherwise require a permit. So it's beyond permitted. It's anyone that would require one. For example, what I'm saying is, hypo is this. Let's say you're minding your business with a handgun, as you have a right to do under Heller and Bruin, and in your neighborhood, 100 people decide to get a soapbox and get in the middle of the street and want to talk about any subject they want to talk about. Under this, I read this, and you tell me if I'm wrong, that that's an event that you would otherwise need a permit, because I don't think you're allowed to block the street without a permit, are you? Are you? Follow my hypothetical. Are you allowed to block the streets without a permit?
Without a county permit, the county permit has nothing to say about that. And I think you're reading from the plaintiff's brief, which omitted the word county when it set out the ordinance. It has to be a county permit for the ordinance to apply.
So it doesn't say would or otherwise require a permit?
Excuse me?
Or otherwise require a permit?
Yes, if otherwise require a county-issued permit. Now, what you're describing.
But put county in there, because then otherwise, so anything that otherwise would require one. So my point is broader than just a permitted event.
Yes, just to be clear.
Is that right?
Yes, the language is in there so that if somebody, as in your hypothetical, should have got a permit but didn't,
right,
the police could still show up with movable signs, put those signs out, and at that point, only after the signs are there, only at that point does the ordinance become enforceable.
But that doesn't matter. Notice doesn't take away the stench of limiting the right. That's like saying, well, I have to say, would you please move, or would you please get, that doesn't matter. You're still prohibiting someone from carrying a gun. You think that it cleans it up because the police have to say, it's a permitted place here, and you need to leave, and please go. If you don't, I'm going to arrest you if you have a weapon. So, but that could pop up anywhere in the county, correct?
No, it cannot. It can only pop up in the places where the county issues permits for, and that is not on county streets because the VDOT controls
am I reading it
its
wrong?
streets.
Is any place that's open to the public?
And
There's no place open in the public?
And where either a county-issued permit has been granted or a county-issued permit should have been sought. Only in those two circumstances.
Well, what part of the county don't cover for permitting?
So this is set out on a website as the undisputed
You
facts.
know the record. I mean, for example, what part? What
Sure.
part is the
Okay,
county
so
not?
there's the government center in Fairfax County Government Center. That's where almost all of these permits are issued for. It's the forecourt of a building, and that's where most protests and other kind of lobbying type meetings take place. So people go get permits there to have an event there. Once they have those permits, the signs go up, and at that point, with the signage there, this prohibition
I
can
see.
be
So
forced.
all the other places in the county, you could block the street and do what you want to do because that's not the ones you listed.
If you do that, you've got a problem with VDOT, with the Virginia Department of Transportation, not with the county, because VDOT are the ones that administer the roads, not the county. That's right.
Well,
Right.
not to get in, I'm sorry.
Go ahead. No, go ahead.
Not to get in the weeds too deeply, but if you moved over to the city of Alexandria, where the streets are controlled by the city, not by VDOT, then it seems like you would have a circumstance where the ordinance under your theory would be valid in Fairfax County, but invalid in Alexandria.
Well, I'm just representing the
No, I
County of
understand that.
Fairfax. I don't know the extent to which, I know or I believe that the city of Alexandria adopted some similar version of the ordinance. I don't know the language of their ordinance, and how they apply it, and how they apply, for example, their own notice requirement. I see I'm well out of time, but I'm happy to answer any other questions.
Thank you, Ms. Carter. Mr. Holbrook?
Thank you, Your Honor. One part of Bruin that the county attempts to rely on, where there's no analog that seems to be proper, at least from the right time period, is unprecedented societal concerns. And I'd like to know, what is the unprecedented societal concern about law-abiding peacefully carrying concealed weapons with having permits for them, hiking in the woods? What are the unprecedented societal concerns? After thinking about that language, a good analogy that came to mind would be, if you remember back in the 60s, we started having hijackings of planes. And before that, hunters would actually bring their gun cases and put them in the hold, where they store coats even today. But because of the hijackings, it became unlawful to carry a gun into the sterile area and on board, and you have to check the gun if you're going on a hunting trip, for example. And I would think that's a good example of an unprecedented societal concern where you can justify, and you can find, I'm sure, analogs to that, whatever they may be. There's been no discussion here about that, but that's a good example of an unprecedented societal concern.
Well, isn't the remedy then for that hiker in the isolated woods to bring that challenge as applied? Ms. Carter mentions that this is a facial challenge, and she listed a bunch of parks where clearly the interests are different. So why doesn't your claim fail at that step?
We don't think that this ordinance, merely because it bans all firearms in all public parks in the county, is the proper way to enforce prohibitions on schools, the tiny portion of parks that might have a school in it.
No, she mentioned a bunch of parks that, she mentioned one that was for special needs children, and parks that are the size of this courtroom, that where obviously the interests are a bit different than the hiker moseying along in the woods by himself or herself. I mean, that
Right.
seems like a challenge for another day.
So our position on that would be if they think that's a sensitive place, any places they think would be sensitive places, they're within these county parks, they need to find a way to establish a general rule that would be applicable to these places and ban guns there, if they can justify those as being sensitive places. But what they've done is equivalent to, and by the way, the Fairfax County Park System is twice the size of Manhattan, the total island of Manhattan. And the Supreme Court in Bruin says that you cannot ban guns in all of Manhattan, even though there are playgrounds and there's schools and there's courts there. And that was a proper challenge. It was brought by two individuals, and yet the court didn't just say that the New York law was invalid as to these two plaintiffs. They said this law is invalid. And so I think that's the same approach we take here, but by contrast with Rahimi, there were analogs like the going armed to the terror of the people statutes that the court found good analogs for banning possession of a firearm by a person found by a court to be a danger, a credible danger to the physical safety of another person. So, and if I could just say one more thing about the 1791 versus 1868 issue, what Justice Thomas said in Bruin was that we've always assumed that the original public understanding from 1791 is proper. And he added that, well, yeah, there's a scholarly debate about whether that's appropriate. And he cited an article by Akil Lamar and one other professor. But what the court said before that sentence was, we've always assumed. And so it's not for us to come before the court, and it's not for this court to say what the Supreme Court has always assumed is incorrect. I mean, the court's going to have to make a final ruling on that if it deems it necessary. But all the case law on, you know, First Amendment, Fourth and Fifth, and all the rest, they've always gone by the original public understanding from 1791. And so for us to go against what the court, Supreme Court has said, we've always assumed something, that's their assumption. They're going to keep assuming that until they change that.
Thank you very much, Mr. Holbrook.
Thank you.
I want to thank both counsel for their, all the counsel for their fine arguments in these Second Amendment cases, which are, as ever, quite perplexing. We'll come down and greet you and adjourn for the morning.